I received an interesting series of questions the other day regarding iBuyers. Some of these questions I will attempt to address in this video podcast. First, what is an iBuyer? An iBuyer is a real estate investor that uses an automated valuation model or other technology to make cash offers on homes quickly, most often purchasing the homes sight unseen. After purchase, the iBuyer then puts the house back on the market. The second question then becomes, when the iBuyer sells, is a seller's disclosure notice provided? The iBuyer never occupied the property, so do they have to provide a seller's disclosure notice? Never having occupied the house does not exempt the iBuyer from providing a notice. However, as discussed in previous videos, the ramification of not providing a seller's disclosure notice is simply termination of the contract. The law states that if the seller's disclosure notice is not provided on or before execution of the contract, the buyer may terminate the contract for any reason within 7 days of receipt. What happens if buyer never receives the disclosure notice at all? The law is silent as to that. Buyers can close without receiving a seller's disclosure notice. Note, however, buyer always has recourse against any seller if seller fails to disclose a defect on the property that he or she knows or should have known existed, and buyer relies on that misrepresentation to his detriment. So if the iBuyer has received a disclosure from his seller, the iBuyer has to disclose any defects revealed on that seller's disclosure notice or be subject to liability. The third question is, why does an iBuyer insist on amending the contract to provide that he or she only signs a special warranty deed and not a general? And how does this impact the buyer? The difference between a general warranty deed and a special warranty deed is a general warranty deed warrants title from the beginning of land ownership, whereas under a special warranty deed, the seller only warrants title for the period during which the seller held title. A special warranty deed does not warrant against any defects in title that may exist before seller's ownership. By insisting on only signing a special warranty deed, the iBuyer lessens his or her liability for any title defects that occurred prior to getting title. Title insurance can be issued irrespective of whether the seller signed a general or special warranty deed. So, provided buyer gets title insurance, there is little impact on the buyer if the iBuyers sign a special warranty deed. iBuyers have special addendums they add to the contracts when they sell their properties. The addendum substantially changes other provisions of the standard promulgated TREC contract. I will address some of these other changes in next week's video podcast. Thank you for listening. Allegiance Title is your trusted resource for results.